Your client's trademark application was advertised in the Trademarks Journal on the 1st of March. A competitor has exactly 4 months to file an opposition. That puts the deadline at the 1st of July. Under the Trademarks Rules 2017, that 4-month window is absolute. You cannot extend it by a single day. Welcome to Patentworld-ai, Lecture T3 for the Trademarks Agent Exam 2027. Today, we map out the complete journey of a trademark application: filing, examination, advertisement, the opposition battle, registration, and the renewal and restoration lifecycle. Success in this section of the exam requires viewing these procedures as a single, unforgiving pipeline. In this system, a missed deadline or a miscalculated number leads directly to the loss of legal rights. We begin at Section 18. Any person claiming to be the proprietor of a trademark can apply. To file, you must establish one of 2 valid bases: either actual use of the mark in the Indian market or a bona fide intention to use it, which the Act terms propose to be used. Jurisdiction is strictly tied to geography. You must file the application at the specific registry office that holds jurisdiction over the applicant's principal place of business. The 2017 rules streamlined the filing process. Instead of submitting separate applications for every class, a single Form TMA now covers all goods and services in a multi-class filing. However, the registry still calculates the fee per class. This flowchart outlines the registrar's 4 statutory powers under Section 18, subsection 3, upon examining an application. We track them with the memory trick AARC. The registrar can accept absolutely, accept subject to conditions, refuse, or call for further information and evidence. If the examiner leans toward refusal or imposing conditions, Section 18, subsection 4 guarantees the applicant a formal opportunity of being heard. If a refusal is finalized, the registrar must provide written reasons, giving the applicant exactly 3 months to appeal to the High Court under subsection 5. Because Section 18 establishes the legal basis, the applicant identity, and the jurisdiction, these details form the bedrock of the application. Errors in these core structural areas often trigger mandatory refusals that a simple clerical amendment under Section 22 cannot fix. This fee logic matrix reveals the pattern behind the TM Rules 2017 fee schedule. Apply this rule. Individual or startup rates are half the company rate. Physical paper incurs a 10% penalty over e-filing. Applying this to Form TMA, e-filing is 4,500 rupees per class for startups. Companies double it to 9,000. Physical filing adds the 10% penalty, reaching 5,000 and 10,000 rupees. If an applicant requires speed, they can file Form TMM to request expedited examination. The e-filing fee is 18,000 rupees, obligating the registry to ordinarily examine the application within 3 months. Filing Form TMO for an opposition carries an e-filing fee of 2,700 rupees per class. Form TMR, used to renew a registered mark, costs 9,000 rupees per class. You can sequence the core forms directly through their identifying letters. TMA is apply, TMO is oppose, TMR is renew, TMP handles post-registration changes, TMU is for a registered user, and TMM covers miscellaneous requests. Alongside the forms, you must attach specific ride-along documents, like Form TM48 for agent authorization, a user affidavit if claiming prior use, English translations for foreign words, and certified priority documents for convention filings. Examiners test these specific numbers because they dictate the financial mechanics of IP practice. Internalizing the baseline formula ensures you can mathematically derive any forgotten fee mid-exam. Even after an examiner accepts a mark, that acceptance is not final. Section 19 grants the registrar the power to withdraw an acceptance if issued in error or if new circumstances arise. The timing of Section 19 is precise. The registrar can exercise this withdrawal power only after the initial acceptance, but strictly before the mark is entered into the register. Once cleared, Section 20 requires the application to be advertised in the weekly online Trademarks Journal. This publication serves as constructive public notice to the world. This advertisement is the specific trigger for the opposition clock. If the registry makes a typographical error in the advertisement, they must re-advertise the mark, and the clock starts completely over. Advertisement marks the point where the trademark leaves the safety of the registry's internal review. It is now exposed to the market and vulnerable to legal attack. When that attack comes under Section 21, any person has standing to oppose. They have exactly 4 months from advertisement to file. Unlike geographical indications, which offer 3 months plus an extendable month, the trademark rule is absolute, 4 months flat. Filing an opposition initiates a full, privately funded re-examination of the mark against absolute grounds under Section 9 and relative grounds under Section 11.
Once the registry serves the opposition notice on the applicant, the burden shifts. The applicant must file a counterstatement within exactly 2 months. Missing this 2-month counterstatement deadline carries a fatal consequence. The application is legally deemed abandoned. The 2017 rules eliminated all extensions for this step. If the counterstatement is filed on time, the process enters the evidentiary rounds, governed by Rules 45 through 47. This includes the opponent's evidence, the applicant's evidence, and the opponent's reply evidence, eventually leading to a hearing before the registrar. The opposition phase operates as a procedural minefield. A single missed calendar date by the applicant instantly terminates years of investment in the application. During this process, Section 22 allows the registrar to permit minor clerical corrections and amendments to the application, provided they occur before registration and do not substantially alter the identity of the mark. If the application survives the gauntlet, meaning it is accepted and goes unopposed for 4 months, or the applicant defeats an opposition, Section 23 dictates that the registrar shall register the mark. This triggers the relation back rule. The mark is registered as of the date of the original application. The legal rights vest retroactively, treating the mark as fully registered from the moment Form TMA was filed. For marks owned jointly by 2 or more proprietors, Section 24 applies. Each co-proprietor can use the mark independently, but neither can unilaterally assign or license the mark to a third party without mutual consent. The relation back principle preserves the applicant's exact priority date. This ensures their legal standing in the market is protected throughout the entire duration of the procedural process. Once registered, a trademark is valid for 10 years from the date of application. To maintain it, you must pay the 9,000 rupee renewal fee via Form TMR. This renewal can be filed up to 1 year before the expiry date. If you miss the expiry date, Section 25 provides a grace period. For exactly 6 months immediately following expiry, you can still maintain the registration by filing the renewal alongside an additional surcharge. If you miss the grace period, the mark is officially removed from the register. However, a restoration window opens. You can apply to restore the mark after 6 months, provided you do so strictly within 1 year of the original expiry date. The registry cannot remove a mark without prior warning. They are statutorily required to send a Form RG3 renewal notice to the proprietor. In the 2026 exam, candidates were tested on this exact requirement. It is mandated by Section 25, subsection 3. Even a removed mark retains legal force. Under Section 26, a removed mark acts as a barrier, blocking any new identical applications for a period of exactly 1 year after removal. This ghost rule applies unless there was no genuine commercial use of the mark in the 2 years immediately prior to removal. Securing the registration certificate dictates a transition. The initial legal battle ends, and a rigid, perpetual maintenance schedule begins. Let's map the full pipeline. You file Form TMA. It faces examination. If there are objections, you have 30 days to reply. After a potential hearing, the mark is accepted and advertised in the journal. Public has 4 months to oppose. If opposed, you have 2 months to file a counterstatement. Upon success, registration relates back to the filing date. 10 years of validity follows, renewable 1 year early, backed by a 6-month grace period and a 1-year restoration window. In practice, an unopposed application will generally clear this statutory pipeline and reach registration in about 8 to 12 months. Time to lock this in with a rapid-fire recap. Question 1. What are the 2 valid bases for filing an application? Actual use or proposed to be used? Question 2. What is the Form TMA e-filing fee for a company? 9,000 rupees per class. Question 3. How long is the opposition window? 4 months from advertisement, non-extendable. Question 4. What is the deadline to file a counterstatement? 2 months or the application is deemed abandoned. Question 5.
When does registration take effect? The date of application. Question 6. What is the duration of validity? 10 years, renewable perpetually. Question 7. How long is the grace period with a surcharge? 6 months after expiry. Question 8. What is the precise window for restoration? After 6 months, but within 1 year of expiry. Question 9. Which provision mandates the RG3 renewal notice? Section 25, subsection 3. That concludes our walkthrough of the Chapter 4 pipeline. You are now prepared to handle the procedural mechanics of trademark applications. Next, in Lecture T4, we examine how trademarks change hands, covering assignments, goodwill, and the Section 42 advertisement trap. Keep studying, and I'll see you there.